All right, we'll turn back now to Vermont, where a sentencing hearing is underway for Joseph Ferlazzo.
He confessed to killing his wife, Emily, when he took the stand, but he said he shot her in self-defense. Obviously, that jury did not believe him. They did find him guilty of first-degree murder. Ferlazzo is now facing up to life in prison.
However, before we do go back to court, let's bring in our guest for this hour, joining us, criminal defense attorney Jeffrey Wolf. Jeffrey, great to see you. Thank you so much, as always, for joining us here on the program. And I want to get your thoughts on what's happening here. I mean, the state is laying out, there's so much to work with here in terms of aggravating factors. And the aggravating factor is particularly important here because that 35 minimum in this case per statute can either rise and fall based on whether the aggravating factors outweigh the mitigating factors.
Yeah, absolutely. That's the way a sentencing hearing is always going to work, right? You're going to have the judge considering aggravating and mitigating factors. And the way I always explain it to clients is aggravating things make it worse, mitigating makes it better. So anytime that you have something that you can bring up to the judge that makes you look better, you're mitigating the circumstance. Anytime the prosecution has something that aggravates it, it makes it worse. So what the prosecution is doing, and what they're doing rather astutely, is taking what the defense has done to try and mitigate things and using them to aggravate it even further. So these character letters that have come in of these women who have said, we met him, he's a good guy, he was so kind to us, they're saying basically he was grooming these women for further relationships. And that is dark, okay? Taking the character letters of the defense and using them against him is extremely dark. That is, if those letters were not vetted well by the defense team, that was a huge mistake.
Well, you know what's interesting is the code specifically states that the state has the burden beyond a reasonable doubt, not only to show the aggravating factors, but to also prove the absence of mitigating factors. And I feel like that's what they've leaned into, Jeffrey, by kind of twisting what the defense has used to say, no, and now saying the only mitigating factor he has is no criminal history. Do you think a court might agree with that argument, that that's it? That's the only thing he has as a mitigation, is he does not have a criminal history?
Well, I think that is the only one that they can't refute, right? Because a lack of criminal history is just a fact. When you haven't been arrested before and there's nothing to point to saying you have a criminal history, that is one that they can't get around. So now what they have to do is attack everything else. And because of that, they have to confess that one, and then they can attack everything else. And so when you can't get around it, you say it's the only one that exists.
That's fair.
Jeffrey, I wanted to ask you, because oftentimes you have the same mind as far as this goes. Do you think the prosecution might be going too far in terms of, like you mentioned, using the letters that were brought in to support him to suggest, with, I'm going to say, not a whole lot of evidence that he was actually trying to groom them, that this was a possibility, things along that nature? You think they're going too far?
Well, I often think that with a jury, okay? And so I think that if they were doing that in front of a jury, I think they may run into that. But when you're doing it with a judge who has just sat there and listened to the trial and seen somebody get convicted, oftentimes judges are former prosecutors, and you find yourself as the defense sitting there and dealing with two prosecutors during a trial and certainly during a sentencing. And so what they're doing is they're throwing red meat at a thirsty dog with this judge. And so they're probably not going too far with the judge. The judge is probably licking their chops at this, quite frankly.
So it sounds like yes, but not with this particular judge, because he's a former prosecutor, right? I got you. All right, stand by, Jeffrey. We're going to get back into court now for more of the state's oral argument ahead of the judge's sentencing.
Still with us, criminal defense attorney Jeffrey Wolf. All right, Jeffrey, if you're that defense attorney, how do you feel when the judge is weighing in and starts peppering you with questions, including that, well, was he intentionally lying or telling himself what he needs to tell himself to get through it? Do you agree with me, counsel? That's one of, that's the case. And I don't know, I'm a little surprised the judge is doing this. Your thoughts?
I'm not surprised, because it happens all the time, and I'm routinely infuriated by it. Thanks for asking, Ashley.
I don't know what you're saying about judges there, but okay.
I'm routinely infuriated. She's doing a great job of keeping it in, and she is being professional. That's what you got to be. She is refusing to back down, which is what you got to do, and she is making a good record, citing case law, telling the judge what the statute says and why she is right and why he is wrong, and he's going to make the decision he's going to make, and she's going to have the appellate record for her client. And that's what you got to do, because judges do it routinely. They have their mind made up. They think they're right. They interrupt you. They interrupt your argument in a way they don't do to the prosecution. As defense attorneys, we're used to it. We get the slings and we get the arrows. We go home. We complain about it to our spouses or our partners, and that's what happens.
Jeffrey, you know,
Michael, I don't know what he's talking about. Do you, a judge, interrupting? Oh, I'm sorry. Did I interrupt you? Okay, go ahead.
Yes, Judge Ashley. This whole thing with the perjury. Again, and again, we're sort of the same mind. These things kind of infuriate me as well. But I want you to give us sort of a sense of the thought behind this type of thing, where a judge is allowed to consider the fact, and again, this can have a chilling effect on someone taking the stand. They have a right to get up there and tell the story as they believe it to be. Now they have to make a determination if they consider it was deliberately lying or whatever the way you want to frame the argument. But at the end of the day, then ultimately that being used against him, not only in the guilt phase, but in the penalty phase as well, Jeff.
Yeah, absolutely. Basically what they're doing is they're saying he was found guilty, so the fact that he got on the stand and said he didn't do it, he was lying. And the defense attorney is calling their bluff, and they're saying, okay, you're saying he's lying, charge him with perjury. You're not doing it because you can't prove it. You can't prove that he was lying beyond a reasonable doubt. You convinced a jury that he killed this woman, but you can't prove he was lying. You can't prove that he knew what happened and that he wasn't just intoxicated or under the influence and thought that this isn't what occurred, and that's why he was saying what he was saying on the stand. And so to get up there and say that he took the stand and willingly lied to the jury, and to say it with a straight face to the judge over and over again as an aggravator, okay, put your money where your mouth is. Let's have a perjury trial in 6 months. Let's go. They're not going to do it.
Yeah, and you know, it shocks the conscience as far as I'm concerned, because again, it was even mentioned, people do all kinds of things to accept something they might have done. So he may have, in his own mind, created a whole new reality.
Yes.
You know, there's just so many answers to the question.
And I think that's what the judge was saying. Hey, that's a possibility defense. And they said, you know, we can't agree with that. But I think the judge gets it.
Yeah, no doubt. All right, I want to mention this. Jeffrey, stand by. If you'll notice, again, our verdict clock is up. The jury has been deliberating in the rock-throwing murder trial now for 3 hours and 11 minutes or so. I didn't even think it would take that long. But anyway, that's going on in Colorado. We'll take you inside that courtroom, of course, once the jury reaches a verdict or if they have a question.
And coming up, we'll have more of the sentencing hearing for Joseph Ferlazzo in Vermont, and we'll hear from that judge. Stay with us.